Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to Our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall, and today's program is How Has It Been Working? A reflection on Europe's General Data Protection Regulation 4 years in. The EU's General Data Protection Regulation, or GDPR as everyone calls it, came into force in May 2018. So we speak today in March 2022. It's therefore been in force for nearly 4 years. The regulation is designed to protect the personal data of individuals and to provide for the free movement of such data within the EU and EEA. It imposes a range of obligations on businesses that collect and use personal data. It was a harmonizing measure which did away with the fragmentation in different national systems across the EU and EEA and related administrative burdens for companies. Following Brexit, the UK adopted the GDPR, so now there is a UK GDPR in UK law. The key principles, rights and obligations remain the same under the UK GDPR as under the EU GDPR, but this is a new and separate parallel regime which needs to be complied with alongside the EU GDPR. There was a lot of discussion and concern about the implications of the EU GDPR when it came into force. It remains a very important piece of legislation and one which has become a model for many other data protection and data privacy laws across the world. Since we are coming up on the GDPR's 4-year anniversary, it's a great time to reflect on how the GDPR has been working and what we've been seeing in practice. My co-host today is Kayla Odom. Hello, Kayla.
Hi, Matthew.
Kayla, what are we hoping to get out of today's program?
Today, we're going to look at what has happened in the data protection and data privacy space since the GDPR became effective. In granting individuals the certain rights with respect to their personal data, such as the right to access their data, the right to data portability, as well as the right to have their data erased, the GDPR was intended to simplify the regulatory environment for international business. When it came out, organizations had to quickly figure it out. They were told, okay, so there's going to be a new way of doing things when it comes to data privacy and data protection, and you're going to have to comply or be subject to fines. We all remember receiving notifications from the various websites that we use about the changes that they were making to their policies as part of their efforts to comply with the GDPR. Since the GDPR imposed changes have been implemented, how has it affected the way that we do business? Have individuals been able to assert their rights under the GDPR? And has the GDPR been working as intended? Over the last few years, we've seen laws with similarities to the GDPR popping up in various jurisdictions, including my home jurisdiction of California. So that's why it's of particular interest to see how the GDPR has been working in practice and what we've learned from it.
As you say, there's a lot to talk about. Very interesting. And who is our guest today?
Our guest today is Odom Penman. Odom is an associate at McGuireWoods London in the firm's Labor and Employment Department. Odom advises on a variety of employment matters as well as in data protection and has experience with the GDPR and the UK's GDPR. Odom, welcome to our program. It's great to have you with us today.
Hello, thank you.
So let's jump right in. What would you say have been some of the major developments in data privacy and data protection that we've seen since the GDPR was enacted?
Oh, wow, that is a loaded question. I mean, where do you even start? So much has happened in the data privacy space. I'm just trying to wrap my mind around it, really. But like you mentioned in the introduction, the consolidation of data privacy norms and values globally, that could be attributed to the advent of GDPR, we've seen data protection laws spring up everywhere, like you mentioned, the CCPA in California, Japan, Brazil, South Africa. So there's been a real cultural movement towards greater data protection and data privacy norms. We've seen specifically the invalidation of the EU-US Privacy Shield by the ECJ, the European Court of Justice, in 2020. So that effectively nullified the data transfer mechanism between the US and the EU, which is obviously something very important. We've seen Brexit, the UK's exit from the EU, and what that means for data privacy, the UK becoming a third country outside of GDPR. But like Matthew said, we've adopted wholesale the UK version of GDPR. We've seen also COVID, the impact of COVID globally. What does that mean for data protection? Everybody working from home, businesses, data controllers struggling to maintain data security in those working environments, and even dealing with vaccination status data, that sensitive personal data. How do companies deal with that? That's been a huge issue over the last year. And we've seen 2021 was a huge year for fines leveraged by supervisory authorities across the board. We've seen some of the biggest, harshest, some might say, penalties being applied to data controllers for breaches. So yeah, it's been a wild ride since 4 years, over the last 4 years.
Wow, when you put it like that, it really has been a wild ride. And pretty much everything that could happen did happen.
Yeah,
I guess.
Sorry, with everything, there's pros and cons with that. There's been some real challenges with data privacy, but there's been some real opportunities as well.
If you take us back to the beginning, when organizations, they had to put in great effort to become GDPR compliant, I guess my question is, was all that effort worth it in the end? Were they able to, live up to the data privacy norms that people sort of expect now that they've been granted certain rights under the GDPR?
It's a great question. And I think how that is answered really depends on where you're coming from. If you are a small, medium enterprise, you might see GDPR as quite an aggressive, bureaucratic, toxic thing that is very unwelcome for your business. You might argue that the added bureaucracy constrains innovation. It's just another layer of red tape that really is a burden disproportionately applied to those smaller companies, data controllers. Or if you are a data subject, you might say, well, now I know what my rights are, I'm aware of them, and I know how to use them, and I can even leverage them to my advantage in certain scenarios. I'm an employment lawyer, as you mentioned at the outset, and I see across the board, data subject access requests, which is now a right under GDPR. Article 15 is giving this right to data subjects to effectively request from data controllers not only what they information about what is held by that about the data subject, but actually to have the information given to them themselves. So we see that being leveraged in litigation, pre-litigation. Employees would often piggyback a data subject access request, or DSAR, on top of a grievance, or pre-claim, or even in settlement negotiations, to sort of really annoy their employers, because they know that those employers will have to apply unwelcome resources, time, and money in dealing with that data subject access request. So, there's lots of cynical things that can apply, but it really depends on your perspective, who you are, and who is really holding the burden of these data subject rights, really.
Makes you wonder whether that was an intended consequence of these requests to access data. Certainly, the GDPR was sold as something that would be a cost savings to businesses, but when you see it being used to burden a business, is the law living up to as is is the law living up to what it was sold to be?
Well, I suppose the core value that GDPR is supposed to promote is to really redress the balance of power and who's holding data. So data subjects are certainly familiar with what they're entitled to. And if you think about how the world has developed, how technology has developed, data itself is such a crucial commodity. It is something that is really valuable in today's world. It's comparable to how gold was, I don't know, in the 19th century. But so if you think about how valuable that is, aren't we constraining? Don't we need to have regulation around that value, that commodity? Maybe it's too early to say whether it's really simplified things or produced cost dividends for companies, because we're still at that stage where people are still easing into GDPR. So one of the core values of GDPR is that you should have data security by design. So at the outset, everything that you do and how you implement processes should always consider data privacy at its core. So there's going to be a period of adjustment, which is going to be very burdensome for data controllers to adjust their business environments to accommodate those rights. So there's definitely been a baptism of fire following the introduction of GDPR, and I still feel that we are feeling that. Lots of businesses have neglected to actually have that implementation at the outset, and so they're doing catch up. They're playing catch up, and quite often businesses can be on the receiving end of a penalty, and that has spurred them into acting, to get their data retention periods sorted, etc., have the security from the outset. So I think maybe the intended consequence to simplify data, to have that cost saving dividend, is still going to be felt maybe in the medium to long term future, once we've really got that culture of data security ingrained.
But I guess, Adam, we talked about harmonization, at least in the EU at the outset, presumably without GDPR, and given, as you say, the increasing importance of data, it would have been an increasingly fragmented system, at least in the EU. So that would have been even more difficult for companies and data subjects going forward.
Yeah, no, definitely. And I think actually, outside of the EU as well, globally, we're having a much more uniform data protection regime felt internationally. And that is just aligning with globalization of trade in data. We kind of need that.
Let's talk a little bit about the fines that have been imposed since GDPR was instituted. Who are the culprits in not complying with the requirements of the new law, or what types of businesses were struggling the most to become compliant, would you say?
Well, that question, I guess, assumes that people are compliant. I think there's definitely a huge lag in genuine compliance and backlog and lots of people becoming compliant. The maximum penalty that can be leveraged in the event of lack of compliance is 20 million euros or 4% of total turnover in the preceding year of a company. But there's been some big hitters in terms of penalties being applied in the last year or so. So recently, or not so recently, but in 2021, Amazon Europe was fined 746 million euros by the Luxembourg supervisory authority for using customers' data for targeting advertising without proper legal basis. So they weren't being transparent enough with their platforms in terms of suggesting things to their consumers. And really that has resulted in a huge fine. Of course, Amazon is a huge global company and perhaps can absorb such a fine, but it really does indicate the premium that supervisory authorities are placing on data controllers for these breaches.
Are the fines working at curbing some of the offending conduct going forward?
I still think that's early days to really evaluate that. we're 4 years in, which even in the history of data protection, that's still relatively early. We've had data protection laws since 70s, 80s, even before that. So although this is probably the most significant piece of legislation that's to happen in the data protection space, it's still pretty early. But in terms of fines, I mean, supervisory authorities have definitely become more confident at leveraging those flop fines. They've also lowered their tolerance, I suppose, for these data breaches. I mean, it's been 4 years. Particularly big companies should have that act in order at this time. But in terms of whether it's working, it's certainly generating a lot of headlines. And that, again, is impacting the psyche of the consumer. I imagine that companies like Amazon, WhatsApp, even dating apps have lost a lot of trust and confidence from their consumers. So ultimately, it's the consumer's decision on where they do their consuming. So in terms of, is it working? I still feel like it's still early days, but certainly if you were an investor, a shareholder in these companies, that would be on your agenda, wouldn't it? Would be, has this company got their Data Protection Act in order? Are they going to be liable for certain penalties, which would certainly impact on the share value of that company?
Talk a little bit about the consumer's perspective. So I mentioned some of the rights that were granted to individuals with the GDPR. And you said that for the most part, people do seem to be aware of the rights that they have. Is that true?
I would say so. I mean, certainly as a lawyer working in the employment space, I would certainly see, employees with grievances being aware that they can, leverage those rights to their advantage. And I think generally the GDPR, one of its core successes has been to really democratize data protection and really generate that culture of data subject access rights.
Which of the rights would you say has been most problematic from a business's perspective?
Well, I think all of them are quite problematic in terms of adding that extra layer. I mean, if you were a data privacy officer in any company around 2018, you've had a full day's work since then. I think you've been pretty busy, but I think I said before, data subject access rights, that has really been all consuming because we've seen an explosion of those requests throughout the 4 years. There's been a tidal wave of these kind of requests because employees certainly feel confident about them, I would say, in my view. During COVID, for example, unfortunately, lots of redundancies were made. Those employees would have challenged those redundancies, either to extract a greater settlement or to be reinstated during that time. And quite often those redundancies were preceded or superseded by a data subject access right. So if you have a company who's grappling, with making efficiencies in the workplace or to, really consolidate their market share during difficult times, to have multiple data subject access requests has been a huge headache. And certainly it's kind of uplifted the veil of secrecy around certain processes like redundancy, etc.
I can imagine. I could imagine a variety of things that could happen after an employee's been asked to leave an organization, with being able to access their data and also, just to know what their data is, so they could transfer it where they were going, or be able to use it, or be able to erase it. I guess that was sort of one of the rights that a lot of people thought might be most controversial, because it's kind of balancing the right of the public to be able to access information about others, or to know certain things, and it's also balancing the individual's right to privacy and to be forgotten. We did a podcast on this topic a while back, sort of when we were trying to understand what is the right to be forgotten. I wonder, over the years, has that turned out to be as controversial as it could be, or is it sort of one of the lesser used requests?
Well, yeah, I think Yeah, I mean, in my experience, in my daily practice, it is one of the lesser used requests. As an employment lawyer, you might see somebody who's been perhaps misleading on their CV and have, been found out, and then they've had a job offer rescinded. That's happened a few times in the last year or so. And as part of that job offer withdrawal, that employee, that applicant just wants to be forgotten, right? They just want to exercise their right to erasure, get off the record and forget about that ever happened. So that's actually happened a few times. And the data controller in that situation is willing to comply. But in terms of getting the balance right, like you said, you need to have the right to freedom of expression, access to information. That's fundamental in our culture and society. But we also need to have that balance with the individual's right and their right to really move on with their lives. I think there's that German court ruling last year about a convicted murderer who was convicted of 2 killings in 1982, and he had served his time and was on release. And he just wanted to move on with his life, and he wanted to, develop certain relationships after prison. But he was finding that to be difficult because he was all over the internet in a Google search. And lots of people found the subsequent German court decision that he should, in fact, have that right to be erased from search engine results. I think it kind of was controversial because, effectively you're having these people be forgotten, their crimes, released effectively from the public sphere. But then you also have that real inference on lack of information. Shouldn't we have that knowledge to empower decisions when we're, considering, hiring people, being in relationships with people? That seems to be the most controversial case out there on the right to erasure.
Adam, how would that work outside the online sphere? I mean, you think of the old style hard copy newspapers. Presumably they would report on that and it would be on microfilm, etc., or however that's recorded now. Why should it be removed from an online search?
I guess that's a good question.
Everything else.
Well, I suppose one of the core values of GDPR is about proportionality. Most people, I would hazard a guess, the vast majority of people get their information online rather than microfiche. I'm sure lots of listeners would be querying what that even is. So I imagine, proportionally, the approach is correct one when you wouldn't go expected to destroy. You wouldn't expect the controller or any controller to go and destroy hard copies because of the lack of access to those. That's my guess anyway.
Adam, if you were advising another jurisdiction that's currently in the process of creating their own data protection and data privacy laws, which of the GDPR rights would you tell them should unquestionably be afforded their citizens?
Well, we talked a lot about the burdens of data subject access rights, but there's a lot of value inherent in that right. Namely, how can a data subject look to exercise their other rights if they don't have access to their own data? So, the right to be informed, the right to rectification, the right to erasure. How would you exercise those rights if you weren't able to have transparency, visibility over the data that's been held? So in my mind, that is a core right. And it is a very powerful right for the data subject. I think it is important that we have visibility and control over the information that's being processed about us. So I would certainly say, as a data subject myself, that is something that I think is very cool to include in any data protection legislation that is being drafted.
I would agree with that. And it sounds like this right has been, for the most part, generally accepted by the population. And now that it's out there, it's sort of like, well, you have to be able to let people access what data is being kept on them or being processed by websites, by organizations. So it's like, once you tell people, you can request what they're keeping on you, and there's more you might be able to do with that data once you know what they have. I think people are going to want to be able to know, and anywhere in the world, no matter where you're located. I know we've been talking a lot about the EU. I guess I'm interested, post-Brexit, have there been any complications with any of the rights or enforcement that the GDPR gave? Or has there been any difficulties during the transition?
I would say not really, because the UK has adopted GDPR pretty much as it was to enable a smooth transition. So we've not really seen a lot of delineation between data subject rights. So there hasn't been lots of different complications that have arisen between UK GDPR and EU GDPR. So it's been fairly smooth sailing. I think the main problems are just those problems generally attached to data subject rights. I think in the future, maybe we might see a bit of liberalization of, data subject access requests, for example. We've got 30 days to satisfy a request, which some might say is quite harsh, particularly for smaller businesses. There's no fee anymore. GDPR got rid of the £10 fee that a data subject would have to pay in order to access information. I wonder if we will see in the future maybe to lock out some subject access requests, a fee being reintroduced, maybe on a staged or staggered basis. There's plenty of things that could happen to that right. And I think in this moment that we're living through, post-pandemic, if I can, say that, there might be a look to liberalize data protection law in order to allow businesses to recover from the pandemic and stop being burdened by what some might perceive as added bureaucracy during the recovery.
Would you say that people can feel more confident now that there's the GDPR, more confident that their data online is protected or secure? Or has the GDPR not really made any difference in that respect when it comes to data breaches or cyber attacks?
Well, I think, it's both, really. Definitely people feel that they're more empowered. People know that they have these rights in relation to their data. The results of these high profile penalties and cases against big companies perhaps have the reverse effect that is now revealed. There's lots of data security breaches. There's lots of trepidation about the manipulation of data protection. There's lots of awareness about the dark side of data protection, being sold, being under this cloud of dark skies, lots of awareness around that. We've seen in the US election, for example, the alleged Russian manipulation of the electorate using data on social media platforms. We've seen the real dark side of that. So there's certainly greater awareness of both the empowerment of the data subject, which is a great thing, but also a real realization that's dawned on us about the real negative sides, the real problems with data security and who's accessing that data and who's transferring that data and what is happening to us as a consumer, as a voter, in relation to that data.
Yeah, I mean, I think over the last few years, there's been several data breaches that have been publicly announced, and people don't know if they're affected. So if you receive an email that says, "Hey, you need to change all your passwords," it's sort of like, is that really all I can do? What are the regulators doing to sort of stop these before they occur? I mean, sure, you can fine organizations after the fact, but that sort of brings us back to the same question of do the fines actually help in getting organizations to really step up their security protocols behind the scenes?
Well, yeah, and another facet of GDPR is to have that data by default design, right? So I think definitely we've seen probably a correlation between those fines being applied and investment in technology to avoid data security breaches and to avoid those penalties. So, certainly if you have a economic incentive to protect data, particularly with data being such a prized commodity, I think it's natural for us to have greater sensitivity to data protection. Most people probably would look pretty dimly on any company that is notorious for leaking data, or would you really trust your bank credit card details on online platform when that company does not have a solid reputation for protecting your data? Probably not. So certainly I think it's been both a carrot and a stick, trying to change that culture of data security.
And technology is constantly evolving, so the cyber attacks of the future that we can't predict right now, you wonder if the GDPR is going to be able to address new challenges as they arise, or is it going to have to be modified and reassessed to keep up with changing times? So I guess that brings me to my final question, which has to do with the review process by the European Commission. Every 4 years, they're supposed to review the GDPR and put out a report. And the next review, I believe, is set to occur in 2024.
That's right.
Is there any issue or problem that you think should be assessed in the next review?
Well, first of all, I think the time period, I think they had the review after 2 years implementation in 2020, and then Article 97 of the GDPR states that we have to have a review every 4 years. Now, I would argue that 4-year period is it's too long. Like you said, technology, social political dynamics are just moving at such a great extent. 4 years is a lifetime of data protection and technology and what happens in geopolitics. I would say we should really have a review every year or every 2 years. I think, lots will happen during that period. And I wonder the look back in 2024. I think they will be coping with just the sheer volume of platforms that are now harboring data. We use on our phones so many platforms: Facebook, Instagram, TikTok, WhatsApp. It seems that landscape is just ever expanding, and I wonder how GDPR is going to be able to keep up with that change.
Yeah, that's a good way to put it. The volume just exponentially, could go out of control with any number of new technologies we encounter. So just the human side, being able to keep up with the data and protecting it and all the requirements that the GDPR requires.
Yeah, 100%. I mean, even in the definition of data, with that change, maybe not 2024, but 4 years after that, 2028, what would that even encompass? Is there going to be things that we can't even fathom right now that would be included in the definition of data? We don't have visibility over that. And like you said, exponential growth in this field, really, it's like lightning speed. And I do wonder if GDPR is perhaps too complicated, too bureaucratic, too burdensome to really chase those changes.
Well, it'd be nice if they simplify, but it's not usually the case that these types of laws are simplified, is it really? But Adam, that's been extremely interesting, and we could probably talk forever about these subjects. But thank you very much. Let's just change gears a little here. We have a couple of things we'd like to chat about with our guests at the end of these episodes. Firstly, what advice would you give a young person or a student who's interested in doing what you do? You obviously have a wide practice of employment and data protection. Do you have any comments or advice you could give?
I would say a few things. I think just technically you should be really on it in terms of what's happening in this space. You should be on top of the movements in, as a lawyer, generally, you are constantly catching up with changes in the field. But to be successful, I think in any job or practice area, but particularly being a lawyer where there's quite a lot of long hours and it can be quite grueling, is to find joy in the subject that you're practicing. As a lawyer, I think if you had no interest in, say, tax, and you were a tax lawyer, or you're trying to get into that space, or if it didn't spark, if it didn't create joy in your life, if you're not looking forward to reading something or discussing something about that subject area with your friends on the weekend, you're not going to be successful in that as a lawyer in that space. So certainly finding something that you enjoy genuinely makes it a lot easier to access that space.
Thanks, Adam. Great advice. And finally, we'd like to ask our guests as well, could you please tell us something interesting or unusual about yourself that we wouldn't know if we only knew you professionally?
If you only knew me professionally, well, I am, and I don't think a lot of people would suspect this, but I am a very good skateboarder. I am in my 30s, so that's probably just controversial in itself that I can skateboard in my 30s still. But I am an avid skateboarder. That would be my surprising fact.
So what is your most impressive trick?
Just remaining on the board, I think. It's very subjective what impressive is when it comes to skateboarding. But no, I can do a half pipe, if you know what that is, Matthew.
I could hazard a guess, but I probably won't because I'll probably be wrong.
Adam,
it's where you drop.
What did you think?
Sorry.
What did you think about skateboarding in the Olympics?
I think it's great. I love to see the skateboarding in the Olympics. Finally,
right.
Well, that's. We usually I have a local park here where we see people skateboarding. So next time I go by there, I will definitely think of you doing a half pike. So thank you very much, Adam. That's all we have time for today, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.